Hi everyone, my name is PERTAMINA. My NPM is 235-2011-063. So I'm here because I wanna do my assignment for my final exam, International Private Law. It's about showing and explaining about my case. My case is the case between Pertamina and Petroleum. It's about gas. Explain the first one is PT Pertamina versus PT Petroleum is a brief international civil law analysis. The first one, I will bring you to this case. This case involved disputes between Pertamina and Petroleum regarding the management of the oil and the gas blocks. Initially, Petroleum was granted exploration rights under Production Sharing Contract or PSC. However, when the contract expired and Pertamina took off working area, PT Petroleum claimed that contracts expired and its rights were violated. Do Pertamina take over the facilities fulfilling administrative and financial obligations? This case proves that the determination of a PAC handled responsibly. Even if the assets returned to the state, Pertamina still had an obligation to settle duties of the Petroleum. The lack of settlement led to the breach contract and legal dispute. And jump to the legal issues. The central legal question is, did Pertamina commit a breach of contract or one prestasi by taking over without completing its obligation? If so, is Pertamina legally bound to pay the compensation or not? Although the contract referred the dispute to international arbitration in Singapore, the substantive law that governs the contract, also known as Lex Causa, remains Indonesian national law, includes Article 1338 of the Civil Code, which upholds that agreements legally made are binding, and then Article 1240 regarding compensation for breach, and then Government Regulation number 35 of 2004 on upstream oil and gas, and then last but not least, a relevant decision of forms SKK Migas, Indonesia's oil and gas regulatory body. The case was examined both through arbitration in Singapore and through the Central Jakarta District Court. Eventually, reaching the Indonesian Supreme Court, the court ruled favor of PT Petroleum, declaring that PT Pertamina had violated the contract. As a result, the court upheld an award of 1.68 million in damage. This ruling also emphasized that even state-owned enterprise like Pertamina cannot override contractual obligation. The court accepted the arbitration result because it did not conflict with public policy. In accordance with Indonesian recognition procedures under international arbitration norms, this case highly significant is illustrating how civil law principles apply even when the state is involved in commercial contracts. The ruling affirms that principle that pacta sunt servanda, that contract must be respected, and confirms that state-linked entities are not above the law. It also demonstrates Indonesia recognized international arbitration awards provided by aligned with national interest and public policy. This strengthens the credibility of Indonesian legal environment in the eyes of foreign investors. That's all from me. Thank you very much for watching my videos. If you have any questions or criticism or suggestions, please reach me. And if you have any question or something confusing, directly please meet me. Thank you very much. Bye-bye.